this guy?
What was his original? What was the original last Right, when you show us the lowdown.
Yeah. Oh, sure. Sure. I love doing that. I love doing that. I love being the bad guy at that.
He doesn't have the gavel. I have the gavel. I might pass it over.
I'm just gonna say that the guy, the clown.
Well, Miguel told the state troopers, if you hear the gavel. Okay. So I go, you know your sign right now? Nothing?
Okay.
So you want to just.
Okay, so it is.
Not a border. Okay. This meeting of the Rhode Island State Board of Elections will come to order. Madam Secretary, will you please call the roll?
Thank you, Madam Chair. Chairwoman Johnson,
Present.
Vice Chairman DeSimone,
Present.
Member Betancourt,
Here.
Member Connor,
Present.
Member Jack Foley,
Present.
Member Madeira,
Here.
Member Schultz, Executive Director Miguel Nunez,
Present.
Legal Counsel Ernie Parcha.
Present.
Thank you, Madam Chair.
Thank you, Madam Secretary, and happy primary day to all who celebrate. That would be all of us. Agenda item number 1, the board may hear and consider any election matter that requires an immediate ruling or determination arising from the statewide primary election pursuant to Title 17 of the Rhode Island General Laws. Director?
Good afternoon, members of the board. I do not have any matter that requires an immediate ruling. However, late yesterday morning, I was notified by the Coventry Board of Canvassers that the polling location located at precinct 0608, the OLC Middle School at 208 MacArthur Boulevard in Coventry was not available to be used as a polling place in today's primary due to a scheduling conflict with that facility. Laurie Anderson, the clerk for the Board of Canvassers in Coventry, requested that the polling place be moved to Manchester Hall, which is located at 585 Washington Street, which is only 2 streets away from the OLC Middle School, or about a third of a mile away. Manchester Hall has already been assigned as a different polling place, so today there are 2 polling places in operation within that facility, which this location can easily handle both. The staff was in communication with the Coventry Board of Canvassers throughout yesterday afternoon, as they were trying numerous times to reach a compromise solution with the school, but they were ultimately unsuccessful. The school is hosting a fundraising bazaar today and did not have enough room to accommodate the polling location. Unfortunately, Coventry does not have any local primaries. There are only uncontested Senate and representative districts in the town of Coventry, and only the U.S. Senate contest, which is statewide, is contested. The affected precinct has 985 voters assigned to it. As of right now, as of a few minutes ago, only 19 voters have voted there today. Due to the circumstances that arose and the timely need for the local board to move the equipment, set up all of their voting locations, as well as set up the appropriate signage at the closed location, I authorized them to move the location to the Manchester Hall. They have placed signage at the OLC Middle School, informing voters that may appear there that their polling place is now located a short distance away at Manchester Hall. This includes lawn signs, which we have provided the local board with, which are specialized to indicate that the polling place has moved, and they can write in the address for the new polling place on them, as well as signage that has been placed on the OLC Middle School entrance. As of this morning, vote.ri.gov has also been updated to reflect the change in the event a voter looks up their polling location online. As to how voting is going throughout the rest of the state, as of a short time ago, 21,922 of the 781,119 eligible voters in the state have voted at the polls, and 11,988 voted during the early voting period, which ended at 4 p.m. yesterday, for an approximate turnout of 4% thus far. The busiest polling place, as of a few minutes ago, is the Scottish Rite Masonic Lodge in Cranston with 371 voters. And the slowest polling place, as of a few minutes ago, was Cumberland High School with only 5 voters total for the day. As far as mail ballots, we have received 10,629 mail ballots of the 15,854 that were requested by voters in this primary. A total of 5,225 mail ballots are still outstanding. All mail ballots will be certified by our peers of staff members this afternoon. In total, we have 31 deficient mail ballots, with 7 already being cured by voters and 24 still outstanding. We will complete processing of mail ballots through our high-speed tabulators by the close of the polls tonight at 8 p.m., at which time mail ballot results will be produced. The board currently has 85 technicians out in the field to support our 346 polling locations in operation around the state today. This morning, the opening of the polls went relatively smoothly. Only one of the 369 DS200s were replaced due to a power cycling issue. We also replaced 6 express votes due to broken screens. Our phone center has been staffed by a rotating personnel, including 4 full-time BOE staff members, 2 representatives from ES&S, and 1 representative from LHS, our poll pad vendor. As of this meeting, we have only received about 36 support calls, which were all quickly resolved. And finally, we expect to start receiving results from polling places and early voting sites shortly after 8 p.m. We expect to post the mail ballot results by 10 p.m. this evening. This concludes my Election Day report, and I'm happy to answer any questions about the Coventry polling place or the summary of voting across the state.
Thank you, Miguel. Any questions?
I have a question.
Sure.
Actually, 2 questions. The Coventry polling place was open on time this morning?
It was, yes.
Excellent. And then you mentioned 6 express vote machines had broken screens. Do you know
Correct.
what caused that?
We have 2 new vendors for delivery, as you know, and we're trying to determine if it is an issue in the move, or was it an issue with the poll workers, or could have been the setup people at the polling location. So it's hard to narrow down. We do pay a cost to repair those. It's not extremely high cost because we do have a contract with election systems and software, but because it is damage, it is something that we have to pay for, essentially.
Yeah, it seems excessive. 6 of them broken, right?
Correct. So we're going to work with just to ensure that the mover understands how high those can be stacked, for example, which we work clear with them, but just to reiterate to them, because we can only stack them 4 high before the pressure on the bottom one, the 5th one will cause the bottom one to crack. But again, we don't know if that was the case. I don't want to put blame on them. It could have been the setup folks at the local board of canvassers. So something that we have to look into.
Okay. Thank you.
Yes, sir.
Just a question for council. Ray, the moving of the polling place, the last minute, since we had approved that in the past, legally speaking, is there authority to have that polling place moved like that?
You mean with respect to the board staff making that decision?
In the local board, I mean, because the local board.
There's nothing in our regulation that calls for it, no. The regulation requires full determination of the availability of the location. And then if there's a need to change it, there's a review process that includes the board itself. When Miguel learned of this late yesterday morning, there was no opportunity to go through any of that. So one thing in your regulation is a reference to the right to bypass any of the time restrictions or requirements of the reg in order to meet the needs of the election itself. Here, the board staff had no opportunity to have any kind of a hearing within the 48 hours. And the only option would have been to have an emergency hearing, or it could have, the board staff could have made the decision and then have the board ratify the board staff decision today. That would be the best approach at this stage.
Just so I'm clear, I don't have any issue with the way the director handled it or the way our staff handled it. My problem with this is, and I think it probably should have had an emergency meeting, given the fact that the event that we'll say interfered with the election is not something that happened within the last couple of days. A bazaar or a fundraiser like that had to be scheduled at least a month in advance at a school. So I do have a problem with it. And I have an issue with it. I don't know what our recourse is, quite frankly, but I have an issue with them in Coventry moving the polling place. And I know this is a small election, but I have a problem with a locality moving a polling place or having the ability or even the attempt to move a polling place a day before the election.
No, my understanding is that local location was never even, that they never agreed to be used as a
Correct.
location.
So I do have an issue with it. I don't know what our recourse is from that standpoint.
You could have you could schedule a hearing on that. You could have the Coventry board appear before you. Obviously, you wouldn't want to do that on a primary day, but you
Correct.
could certainly have a hearing. And I think something along those lines would be appropriate, just to find out what along the process went wrong, because everything has been approved
Right.
and everything has been voted.
And my real concern is that if this were a situation where it were pipe broke in the school, some issue of that nature, okay, it's an emergency, it's got to be moved. I just think for them to throw that on our staff and our director the afternoon before an election, I just think is somewhat unreasonable. I don't know that I'm requesting a hearing, but I would at least request that they provide us with some documentation and some information regarding how this happened and why it happened, frankly. And if that involves the school department or it involves the town, I just think we should be advised of it.
I also, Madam Chair, I also
Yes, ma'am.
wonder if it's appropriate, I don't know, it's not actually on the agenda per se, but is it possible for the board to take an action to ratify the actions taken by our?
Yeah, I believe you could. I believe you could take that action, and then we could have a posted agenda at a later time. If it's with Coventry or not, you could take further action if you thought that was needed. But a motion to ratify what the executive director was confronted with in a very exigent situation would make sense.
Okay, I would
to
like to
me.
make that motion then, Madam Chair.
And I'll
To
second the motion.
ratify that action.
I'll second the motion and just add that, we do make an inquiry from Coventry as to exactly what happened.
Okay.
I think it's a bit
can
unfair
add that to the
I
motion
think
as
it's a
well.
bit unfair that they put that on the director at the last.
I agree.
Okay, we have a motion and a second. Any further discussion? Hearing none, all in favor signify by saying aye.
Aye.
Any opposed, any abstentions? The ayes have it. Agenda item number 2, the board may discuss and vote to approve the minutes of the meeting of August 15th, 2024. Any discussion on the minutes? Hearing none, do we have a motion to approve?
I'll move to approve those minutes.
Second.
Moved and seconded to approve the minutes. All in favor signify by saying aye.
Aye.
Any opposed? The ayes have it. Agenda item number 3, the board may discuss and vote to approve the minutes of the meeting of August 29th, 2024. Any discussion on the minutes? Hearing none, do I have a motion to approve? Moved. Do I have a second?
Second.
Moved and seconded. All in favor signify by saying aye.
Aye.
Any
Madam
opposed?
Chair, I abstain.
Yes. One abstention, and the ayes have it. Agenda item number 4, the board may discuss and vote on a motion to reconsider filed by Scott Sivko regarding the rejection by the Newport Board of Canvassers of his declaration of candidacy for Newport City Council Ward 3. And I think, Ray, we're starting with you.
Yes, I'd be
Okay.
happy to. Is Mr. Sifko here? If you could come on up.
Good afternoon.
I'll just give a brief introduction just to frame the legal issue, and then Mr. Sifko, if you want to make a brief statement, you can, but
Just make sure your
We're-
mic is
Just
on.
Oh,
can
yeah.
Yeah. You're gonna have to hold that button down until the green light comes on.
Yeah, it's.
There you go. Oh, it just turned green, Patty. Oh, there you go.
Great.
Good afternoon.
Good afternoon.
Legal counsel, is this at your discretion? This comes under the RICR Title 410, Chapter 20, Subchapter 0, Part 22. It's the rules of practice and procedure regarding appeals from local board of governors. I guess at this time, I would like to ask if we can move into a pre-hearing conference, an executive session. It would open us to have a more thorough conversation. Whereas today, we're just here to hear on the motion to reconsider, which I'm prepared to make, but I'm also prepared to look at the totality of the matter. So we maybe take a brief recess.
well, that's up to the chair, but this would normally be a motion first. If that is approved, then if the board thought there was a need for any kind of a scheduling conference, they could do so. But why don't we just hear from the board first?
Yeah, I'll defer to my legal
Well, I
counterparts.
was just
but-
gonna ask, are you asking for a pre-conference with our legal counsel?
Well, this is a pre-hearing conference for the motion to reconsider.
Ah, interesting. No, I think we're beyond that stage. As you know, we've already had a full decision by both the canvassing authority and then which was back in July, and then by the Board of Elections on August 15. So the only thing left before the board is whether or not they want to even consider reopening the matter, which is something I just want to briefly frame for the board, and then Mr. Sifko, you can respond. The standard for a motion to reconsider is the same as the standard used under Rule 60 of the Superior Court Rules of Procedure in any Superior Court action, which would deal with the modification of a judgment or an order. The motion to reconsider that we have in our regulations is not designed by its nature to allow a litigant to advance an argument that could have or perhaps should have been presented originally. There must be evidence of either a mistake, inadvertence, surprise, or what the courts refer to as excusable neglect. A motion to reconsider can be granted, but the courts have ruled that the granting of such a motion should be done sparingly to bring finality to the case. There must be evidence that what was not introduced is material enough that it would have likely changed the outcome of the underlying proceeding and the decision, and that the evidence was not discovered at the time of the original hearing if the litigant had exercised ordinary and due diligence. That gives you some guidance as to when and if anything that comes before the board should be reconsidered. Now, in this case, we have to remember that its current posture involves someone who's trying to get on the ballot for an election that is taking place as we speak. Now, admittedly, there is no primary. Is that right, Mr. Sifko, for your race?
That's correct. If I were to be entered onto the ticket, it would not be a primary today. It would come up in November.
The general election.
Because there is only one person who's running uncontested at this time.
So what we have is a decision that was made by the canvassing authority back in July, in which the local authority determined that Mr. Sifko did not have an address in Ward 3 for at least 30 days prior to the time that he was declaring for the Ward 3 council seat. And you heard from the administrator for the local canvassing authority at our hearing on August 15, and he also presented evidence at the local hearing back in mid-July. No evidence was provided to you on August 15 to substantiate that Mr. Sifko was indeed residing in Ward 3 for at least 30 days prior to his declaration. There was nothing that was presented to that effect. But that's the standard of review for you as the board. And Mr. Sifko, with that in mind, do you have something that you thought you could not introduce at the time that this was heard back in August, mid-August by this board?
Yeah.
And what is that? If you just tell us so that the board, so they would know what the basis of your motion is.
Is this my turn to?
Yes.
Ray, do we need to swear him in doing?
Well, yeah, let's see. If you're going to present any kind of testimony, yes, we should swear you in. If it's purely argument, then we don't need to. But I think just to be on the safe side, Mr. Sifko, why don't we swear you in case you provide any testimony in your support?
Well, I'm prepared to make argument here today.
Solely argument? Well, in that case, you would not need to be sworn in. So you can proceed.
So, I gave notice to Executive Director Miguel Nunez yesterday that my grounds for this reconsideration are the title itself that governs this matter and 2 recordings that I have, which I'm prepared to give you today, which are my initial conversation when I dropped off the paperwork, the appeal with Mr. Nunez, and a follow-up with Deputy Director Johanna Petrucia the day following the hearing. What I think, the reason we should be reconsidered is because I don't think we followed the standard, the rules of practice and procedure regarding appeals from rules by local board of canvassers. After the filing, Part A under 22.6, there was a time for response that the respondent did not choose to submit anything in writing. That was their discretion. And then we moved right, which takes place at B, and then we moved right to Part P, the public hearing. And the reason I take issue with that is that when I filed my notice of appeal, I was instructed according to the procedure to provide a brief but concise description of the alleged error or law or regulation sufficient to apprise the board and any respondent of the nature of said appeal. Brief. I did not get to file my actual brief, and we did not get to a briefing schedule. In fact, under Part L, I should have had 10 days. And when you look at Part I regarding time for computation of these 10 days, it includes Saturdays and Sundays and legal holidays. So all that considered, including Saturday and Sunday, it was only day 9 that the hearing was held. I did not have time. I did not have the time that's according to here to file my brief, at which point the respondent would have 10 days to file their counter brief, and then we could have a hearing. Now, when I dropped off my, so I guess I don't want to do testimony, right? So.
But Mr. Sifko, there are 2 issues with that. First, the regulation that you're referring to also says that any of those time deadlines can be bypassed under the appropriate circumstances. And here we were trying to accelerate, not by much, but we were certainly trying to get this resolved so that if you were going to be on the ballot, you would have as much opportunity to be so as possible. That would be the first thing. The second thing is everything you just discussed or raised occurred before the actual hearing took place before this board on August 15. So anything that you thought you had a right to argue could have been argued at that time. But on a motion to reconsider, you don't have a second bite at the apple to come before the same board, the same tribunal, weeks or months later, weeks later, to raise something that you could have argued at the time of the scheduled hearing, either in person or on the papers.
Well, sir, when,
Excuse me 1 second, sir. Counsel, can I just ask, I'm a little confused in looking at the papers. I have a copy of an email from our director on Friday, August 23 at 3:18 PM, sending out a copy of the order. And then the heading of this original email is Thursday, August 29, with a request for reconsideration. At least that's what the timeline looks like to me. I think under our rules, it's a 5-day process. So unless
It
I'm
is,
miscounting, it's 6 days. So
Yeah, I
are
would-
we even timely as far as the motion to reconsider?
I remember Miguel and I spoke about that. I cannot remember if it was on the 6th day or on the 5th day that we actually received it. I thought it was a very close call, and given that he is a pro se litigant, I thought it more appropriate to have the matter brought before the board.
and to respond to that, one moment. Under filing requirements, G, Part 2, all pleadings shall be liberally construed in errors or defect therein which do not mislead or affect the substantial rights of the parties involved may be disregarded at the discretion of the board. So I think that was where you were going with that, legal counsel.
Well-
Look, regardless, the question was for legal counsel. I didn't expect argument on that. But my situation in this is, if we're going to hold to the letter of the rules, he had 5 days. This was filed clearly on the 6th day.
I would have to check
Well,
on that.
the email that I've got in front of me says, sent Thursday, August 29th at 8 PM. That's the email from Mr. Stivko, requesting a motion to reconsider. And then the prior one is August 23, unless there's some email in between that I don't have in front of me.
I believe part of that was on the 20th, before the order was actually signed. He submitted a motion to reconsider, which was the question was whether he could file the motion before the order was written, and we discussed it.
Procedurally, how did we know what he was requesting at that, like, what was the reconsideration at that point? There was no order filed by the board. Again, I'm talking to counsel, please.
Yeah, I don't have the 20th email in front of me. I do recall there being an informal request by email from Mr. Sivko, and Miguel has refreshed my recollection on that point, and that I thought that while it may not have been technically complete, it was appropriate, given that he is pro se, to factor that in when deciding whether or not to hear it.
And additionally, just as for argument, the conversation I have with Deputy Director Johanna Petrucia does discuss the following day after the hearing, my intention to file a motion to reconsider. So I did notify.
On that recording?
On that recording.
So Ray, maybe if you could set the parameters for him and he can make whatever argument he has for reconsideration.
That is what.
I think he's arguing the original merits, not why
Okay.
he should reconsider it. At least that's what it sounds like to me, but.
I-
Well, we're over here on whether or not we're even allowed to have the motion to reconsider here today. We're here for the motion to reconsider today.
That's the only thing that's before the board is a motion to reconsider.
That's right.
Okay.
And to that, counsel, you said that surprise or mistake were reasons for the board to justify reconsideration.
Mhm.
And I just think that because there was no accelerated schedule approved and given to me in a reasonable and timely manner, that said, we were going to have a hearing in 9 days, you're not going to be able to file a brief.
No one said you couldn't file a brief.
Well, I have 10 days to do it. And that if my time to file a brief would have been less.
Well, the thing you have to remember, Mr. Sifko, is that in an election cycle where you have at times 24 or 48 hours for this board to make a review and decision on any challenges, it behooves you to get the papers done when you're given notice, 9 days notice for a hearing. You had that opportunity. You indicated that you would not be there because of your observance of a holy day of obligation. That was your right, but you certainly could have filed a memo to the board that fully explained everything you wanted to have presented for the record. To say now that you need that opportunity, want to have an additional pre-hearing briefing schedule, the board is well beyond that stage in the election process.
Well, just to correct what you said, legal counsel, is that when I spoke with Executive Director Nunes on the 6th, when I filed my appeal.
The 6th.
The 6th, our discussion, again, the other conversation I'm submitting, is that I was requesting the 15th to be a pre-hearing conference, and I mentioned at the time my belief that it's a holy day of obligation, and I understand that this board at the hearing said, oh, well, that just means you have to go to church for an hour. Look, we have 8 days a year. Christmas is one of them. New Year's Day is one of them. Certainly once they go to church for an hour and then get back to work on those days, it's a similar weight. But to the end of that, it like you said, legal counsel, it stays open for business, okay. But I did not have the time to file my brief. I would like to file my brief. It was 9 days. I'd like an additional 2 days. And the reason I figured 2 days is because I should have one. And if once I file my one, then the respondent has 10 days, except the 10th day falls on a Saturday, which means with the time, again, if the final day falls on a Saturday or Sunday, then it goes to the next business day. So they will have 12 days. And ever since that hearing and ever since that, I spoke with Johanna Petruccia the next day, and there was supposed to be, I was informed at that point that there would be a final order coming out over the weekend, at the latest Monday. It didn't come out the following Friday. So I've been, we're in this delay because there was no, well, they could read that regarding the accelerated schedule, because I think that's important.
To the chair, I just have a question for Mr. Sivko. Is part of the consideration for the motion to reconsider, it sounds like we have to have additional information that was reasonably not presented at the first hearing. Is there, in the intervening time, which I don't know what the total time frame is, but obviously much longer than 10 days, is there something that, although I guess this is a yes or no question because you're not under oath, so you can't present it, but is there some additional information that you feel like we were missing on the day of the original hearing?
Yes, absolutely. My brief would be my full legal argument, apart from what I just had to file in the notice of appeal, a brief but concise description of the alleged error of the law and regulation, sufficient to apprise the board and any respondent of the nature of said appeal. I would, again, flipping all the way to Part L, a complete and concise statement of the facts, and prior to proceeding before the Board of Canvassers, the identification of the errors claimed, a recitation of the questions raised, and the basis for petitioner's contention with the order, decree, and other action by the Board of Canvassers was an error, and the presentation of relief sought by petitioner. These are all things that were not required for me to file in the notice, and that I was preparing and did not.
But it sounds like
it
sounds like you're asking for the board to almost hear this as a motion to extend the amount of time to file your original brief or memo. Like I said, we're well beyond that in the election process. And it's been almost a month since the board itself has decided, and almost 2 months since the canvassing authority has decided this. The idea of an extension of time to file the initial argument is not grounds for surprise or excusable neglect. I think what you're saying is that the board should have exercised its discretion and not heard this on the 15th of August. It heard it and it decided it. So what we're left with is whether or not you have additional evidence that you could not present at that time that would have altered the outcome of this. That's really the standard for today.
One moment. Council, perhaps you can help me. Where is the part that discusses accelerated schedules?
I don't have it in front of me, Mr. Sifko, but the regulation does say that the board can bypass any of the deadlines set forth when appropriate. And here, we're dealing with an election coming up. With the publishing of ballots, we don't get much more an accelerated set of deadlines than what we have from our General Assembly for getting those ballots out to the voters.
Through the chair, did we get a revised brief already from Mr. Sivko, or is it not, Mr. Sivko, is it not complete yet? What is the status of the,
I was told,
the brief.
when I called on my 10th day, I was told that the decision has been made. I will be receiving a final order.
yeah. I guess
Maybe
what
by the end
I'm,
of the day, maybe over the weekend at the latest
Yeah.
Monday. That's what was told
I
to
know
me.
all the
That's
the
not yet.
deadlines can be daunting. It's a lot to juggle, but I guess my question is, in that, since that 10th day, or when you did have that conversation and found out that our original decision, have you worked on the brief to provide that to illustrate or document the additional information we didn't have in the first hearing?
Of course.
And do you have it here with you, or is it something that?
I do not. We're here just to have the reconsideration so I can file the brief. This was something that was set in the motion by something being entered at that time.
So I guess maybe we should ask, since we don't have the brief, what that
Oh.
piece of information is, because I think that's material as to
Yeah.
whether we reconsider.
Yeah, what did Mr. Eastman say? I didn't hear you.
He just said he thinks that
I
makes sense.
think that makes sense.
Yeah, I mean, I think if you want to proffer the evidence that you were unable to, through due diligence, present at the hearing on August 15, you can do so.
Sure.
Would he need to
so-
be
And I think
would
you
he
need
need
to
to be
tell us,
sworn in?
I think you need to tell us why you couldn't bring it in
Yeah,
on that day.
that's part of the.
I'm sorry, Jim, would he need to be sworn in to give that?
It's a proffer, but I think to be on the safe side, we should, but it's a proffer in the sense that he's just presenting it, saying whether or not I can actually prove this. This is the fact that I claim I would be able to present if you had a hearing.
Got it.
But if we
Okay.
could, Mr. Sifko, just swear you in, just so that any
I
statement you make about the facts that you wish to present is under oath, that would be helpful.
Again, I'm just here to make argument today. I did find that section that we found earlier, which is it's actually in the briefing schedule. And it says that unless an abbreviated or extended schedule is entered by the board, the petitioner shall file within 10 days of his or her appeal a memorandum that contains. So when was an abbreviated or extended schedule, when was an abbreviated schedule entered by the board? If on the 6th I filed my appeal and the next time the board met was the 15th.
When did you receive your notice that we were going to hear your case?
The email was sent 2 days beforehand, which I do not think is reasonable because I had previously discussed 9 days beforehand the idea of having a pre-hearing conference on that day.
Well, Ray, and again, correct me if I'm wrong. When I look through this pre-hearing conference is set at your discretion. Legal counsel to the board may establish a pre-hearing conference. Doesn't mean you get a pre-hearing conference in every case.
Of course not.
Right.
At the
And
discretion of
did
the
you
board.
ever
Even a hearing.
Did
is
you
at the
ever
discretion of the
request a
board.
pre-hearing conference with legal counsel? Because the pre-hearing conference is something for board's counsel, and then either appellants or other counsel to sit down and narrow issues. That's how I understand the pre-hearing conference.
And to whittle down the facts that may be agreed upon.
Correct.
And I do remember that Mr. Sifko sent an email to Mr. Nunez saying, I wanted a pre-hearing conference, and I responded to Mr. Nunez, and I believe you understood this to be our position, that there's no need for a pre-hearing conference here because this was not an evidentiary hearing that would require basically a trial. This was a set of facts that you have, a set of facts that the local board has, and those could be presented in a matter of minutes, as they were by Newport. And you could have also presented yours in a matter of minutes at that time on August 15, had you been here. But I saw no need for a pre-hearing conference to go through an elaborate schedule for briefing, stipulation of facts, or anything of that nature. The board, especially with elections matters, moves at a very fast pace, as do the courts. I have been involved in cases that have had a full hearing within 2 days of the appeal when it involves someone's right to run for office. It's a very, very fast pace.
So I guess, Mr. Stivko, if I could just kind of streamline this for you. From my perspective, and I'm only one vote here, but
Vice Chair.
I think what you need to do is you need to tell us why you think we should reconsider this.
Yeah.
And the basis for your reconsideration beyond these procedural items, what evidence, if any, we overlooked or was not presented, or why it wasn't presented if there is some excusable neglect under the law, or some other reason why we should reconsider something we had a full hearing on. So at this point, the burden is on you to do that. And it goes beyond simply saying, I needed more time to prepare a brief.
So I think one of your original questions before your last statement was, did I ever discuss with legal counsel?
Right.
Both my conversation with the executive director and the deputy director, I had requested contact information for the board members and for the legal counsel, and I was never provided with any. I was told that whatever information goes through staff, and they will relay that to council. I would have loved to have had a conversation as a representative of my side and your council and the other council.
Going beyond that, though, you're here today on a motion to reconsider.
Motion to
Tell us
reconsider.
why we should reconsider this.
Because there was no abbreviated schedule entered by the board. I had 10 days to file,
You didn't have 10 days to file once we scheduled a hearing.
which was only 2 days before.
You didn't have 10 days to file a pre-brief once we scheduled a hearing. You could have appeared at the hearing and requested more time. So tell us why we should reconsider this matter today. Why should we reconsider what happened in that last hearing? That's what this is here for. This is not here to say, we didn't give you 10 days, so now we have to restart the hearing process. It's here for you to tell us what the reasons are, as outlined by our counsel, as to why this matter should be reconsidered.
Why?
Then if we reconsider it, then you can bring all of these other issues to the fore.
Okay. Vice Chairman.
I'm not the chairman.
I said Vice Chairman.
Okay.
I disagree with your legal counsel's interpretation that there was no need for evidentiary proceedings.
Okay.
And other than that, is the
On
hearing
what,
itself
on what,
on the
on
calendar today?
what, well, first of all, there were evidentiary proceedings. They were held here before us. People testified. Those are evidentiary proceedings. So, and you may disagree with what our legal counsel says, but frankly, our legal counsel's opinion is controlling here before the board. And many times, people in your position and other attorneys disagree with our legal counsel, but his opinion is the opinion of record here. So just from that standpoint, if you have any information, then you should give it to us, because this is your chance to do it. So any information you have that either you couldn't provide or you didn't provide at the last hearing, this is your chance to give it to us.
With all due respect, Vice Chairman, I'm here today on a hearing for the matter to reconsider because of the procedural errors that were made, the mistakes, and the surprise in terms of the short notice of the hearing. I think that they might want to say that I had 9 days notice. The email was sent 2 days before that. I think I read it the day before. Okay, so and it originally stated 9 days beforehand that I would like a pre-hearing conference, and so that's where we're at. And if I'm at the mercy of the board, I would also I would like an additional day. I would actually additional 2 days, but I think but just by matter of the 10 days, I should have one more day so I can give you my entire case. I'm here today just to get you guys to reconsider. To ask me to also come here and present on my appeal itself is not why I was told this hearing was happening here today. And so, if you would please give me another day or two, and we'll have that brief in. They can have their brief filed, and we set it down for a hearing.
I just want to point out that I did notify him on August 7th that Ray had, that he was not going to have a pre-hearing conference, that this matter would be heard before the board at the hearing. So there would be no pre-hearing conference, which in the regulation is at the discretion of the legal counsel, as you had mentioned. So I did make him aware of that on August 7th.
I'm sorry, when, Miguel, did you say that?
August 7th, the day after he filed his appeal.
And he was made aware that the hearing here was on August 15th.
Correct.
That was on August 7th.
That same day, I notified him there would be no hearing conference, and that it would be heard at the meeting of the board on August 15th.
Okay.
So that's more than 2 days, as you mentioned. So he had mentioned 2 days, but you're saying it's over a week. Thank you.
And then one question for Ray, if I could. The fact that we scheduled our hearing on the 15th and notified Mr. Sivko fulfills our, basically, we made an abbreviated attempt at this. It was not the full 10 days, but the fact of the matter is that we scheduled the hearing. So
That's right.
we used an abbreviated schedule.
And the parties were allowed to present evidence, present witnesses, present filings before we had the hearing on the 15th, yes.
Do you have a copy of that August 7th transit?
Yes, I do.
May I see it?
Sure. Do you, would you mind if I print that out for you, or do you?
Not at all.
I have two.
Thank you. We should mark this for the record just because it is being discussed at this hearing. This can be marked as Exhibit 1.
Say, Ray, the, the appeal from the Board of Canvassers of Newport, this was an appeal from their decision. And this was not a de novo hearing on the August 15th, is that correct?
That's correct.
So unless he can produce evidence that should have been presented at that October 15th, that would anyway affect the decision of the Board of Canvassers that they should have considered. You want to hear what he's going to present. We'd like to have some semblance of what evidence you would have offered on August 15th that had you been here.
Yes, and board member, I did begin this hearing today with a request of legal counsel to have a pre-hearing conference. Because at a pre-hearing conference, all parties shall attend the pre-hearing conference fully prepared to discuss all matters involved in the proceedings. We're here today to discuss the motion to reconsider, and procedurally, I do not think it was correct. Responding to the email that Executive Director Nunez just introduced, this was for a tentatively scheduled August 15th at 2 p.m. It was not confirmed until 2 days prior, where it was changed to 4 p.m. That was a surprise, coupled with the mistake. Just regarding, there was no, the board didn't meet between when I filed my appeal and when the hearing took place. So if under open public records, when did an accelerated schedule take place? And the answer is it didn't. The board never approved it, an accelerated schedule. So.
Yeah, but the board does not approve accelerated schedules for hearings. The board staff, including board staff, schedules the hearings and the board then makes decisions. But I think the email was quite clear that there was an urgency to getting this decided. In fact, the email from the executive director to you makes clear that ballots needed to be published by mid-September. We were mindful of the need to have a very quick decision by this board, especially if on August 15, you did provide evidence that required the board to remand it. I remember thinking, what if this gets remanded to the local board for further adjudication? That was very much in my mind when I was thinking about when this would be heard. Elections move at a very clip pace, and none of us have the luxury of delaying our decisions or our actions. Things move very, very quickly, and it behooved you to get this before the board after Mr. Nunez told you that it was going to be heard on the merits whenever it was scheduled, and he said that it would likely be the 15th. And and be ready for that. And then be aware you'll be getting notice of the actual confirmed date, which he did then followed up with.
So but the question is, when was the abbreviated schedule entered by the board?
I can't answer that again. I have answered it, I hope, to the satisfaction of the board and hopefully to you. But I think I've made our position clear as to why this was done as quickly as it was.
Then in reply, I would just submit this into evidence as well. And maybe we can hear them at this time.
That and that is,
The conversation with Mr. Nunez upon filing. In that, you will hear that he mentions that we have time. So I don't understand.
what's the date of that
why-
recording?
That was August 6th.
And then you have the following day, a communication from the same person telling you, we're going to move and we're going to move very quickly, right? I don't know what's on that tape that you have, but the last thing that I have on the record is this exhibit that shows that Mr. Nunez put you on notice. This is going to go forward very quickly. We need to get the ballots published.
But there was no primary in this case. In the present case, this was a general election issue. And it could have had time to file a brief, could have had time to reply brief. We would have been done by now. If I had my extra day, 10 days after that, that would have been the end of August. And we would have had a hearing. This would have been it.
Yep, Commissioner.
Mr. Sivko, I think we understand. I think I don't speak for the board, just for myself. The procedural stuff is not consequential to why you're here today, in my opinion. What I want to hear is if there's something, it's been 25 days since the 15th, right? Roughly, give or take. What piece of information did we not have on the 15th that you have? I know you might not have it written down, but in your head or wherever it is, can you tell us that we did not have on that day that we made that decision? If there's something that we were missing on that day, then if you tell us, then I think that would be, and if it's compelling enough, I'm sure the board would vote to reconsider, but that's all the procedural stuff is not, at this point, it's been 25 days. So you had certainly some time to think about what may have been missing on that day. Is there anything that you feel was not said about the facts of the matter on that day that we don't know about?
There's plenty. And how do I make this argument without testifying?
Well, again, if there's
I mean, you could
piece of
testify.
information,
You-
we'll swear you in, and then you could say, "Oh, I have a electric bill that shows I've lived there for 3 months," or that's an example, but I don't think there's no prohibition against you giving us that information because it's material to what we're considering here. If you don't have that, then I don't think we can reconsider. I think we need to get to the meat of the matter here, because the procedural stuff is
That's exactly what I want to do, but coming from behind on a motion to reconsider, instead of having for a hearing after a time to file a brief without an abbreviated schedule coming forward, I mean, we can move into executive session right now. And I would
there's no in my opinion, again, no reason to move into.
I would agree
executive
with the commissioner right now. I, for one, would vote against moving into executive session. I agree with the commissioner 100%. I
And-
think he's keyed in what the issue is. I think you need to tell us what the issue is beyond the procedure, beyond you not having a pre-hearing conference, beyond the 10 days, beyond whatever items you would have filed. I think you need to tell us factually what we were missing or what you think we were missing.
So the opportunity to cross-examine the witnesses, without giving testimony, how do I make argument?
Well, Mr. Sivko, if I could, so here, your choices are this, I think, again, if there's something on those recordings, if there's something we did not hear on that day that you can argue, you can tell us. Or if you're saying there's something, but it would be testimony, then I will swear you in and you can provide us with that information. Unless I'm missing something, Ray, those seem like the two choices.
There's plenty. Again, I'm not here today to file the hearing. I have everything to discuss.
So we're
I'm
here,
I'm-
you're
I'm
here.
I'm here just because I'm already set back. I'm already in a, and the hearing went the same way, which is in evidence that the board thing. They opened that hearing. This is argument. They opened that hearing with a motion to uphold, the election administrator's decision. And then after that motion was on the floor, argument was made. Rather than coming in and having a hearing, one side speaks for 10 minutes, the other side speaks for 10 minutes.
Which is what would have happened, sir, if you were here. And I understand your reason for not being here. It was at the last minute. You knew of the observance of the holiday. You knew more in advance than the public even knows for that the hearing was going to be 8 days later. So again, you would have had that opportunity to make your argument. They were sworn in, they testified. You can be sworn in today and testify and give us the information you say we're missing. That's the choice that you have. Because I don't think, and again, I know like it's a general election, but we still have an entire operation to run today from the primary. And so I think we're here. We're giving you our time. We're ready to listen. So would you like to be sworn in?
I would not like to be sworn in, but we can have a hearing in a few days. If you want to approve an abbreviated schedule now, we'll have time to.
There
prepare
was
for
an
that.
abbreviated schedule. The director, again, we do not need to approve. That comes from the board staff. And on a phone call and in an email, he provided you with the date and he provided you the reason why it had to be under the, 10 days. So again, I'm not, that I understand why you keep putting that forth, but at this point, we're not going to consider that reason. So again, you need to make that decision, but I'm just going to say one more time. If you'd like to be sworn in, you can provide us with additional information that you say that you have there.
So the only other thing I could add for argument's sake is under standard of review, part N, part 2, where Board of Canvassers' decision is not based on a complete record or without an opportunity for parties to present evidence, cross-examine witnesses, make objections, motions, and oral arguments, then the board shall remand the matter for further evidentiary hearing or shall allow the parties to supplement the record with testimony and evidence during its own proceedings. In the event the board conducts its own evidentiary hearing, it shall make its factual and legal determinations de novo without deference to rulings made by other Board of Canvassers. Again, by argument, it was a motion to uphold the election administrator. When we got to those issues that you want to discuss right now, I was not given the opportunity. And so under part N, it says you shall remand it to the local board for further evidentiary hearing. And if that's, I would ask the board to do that today if we don't want to continue this and have a hearing in a few days or the next time you meet at your discretion. But I would say that.
You were given the opportunity. I just want to say that on August 15th, you had that opportunity. I mean, I had opened it up to other board members. And again, if the canvassers were here from Newport, you would all be sworn in, they would be sworn in again, and it would be testimony, whatever we needed to do. They're running a primary and they're not required to be here. They were required to be here on the 15th and they were.
And that's what I'm asking today, to have reconsideration. So, yes, Vice Chairman?
Go ahead.
I guess I'm going to reiterate what
Commissioner Giacofoni asked you. Do you have any factual information you want to present to us today to support your request for reconsideration? Meaning any facts that you think were not considered. For example, I think the commissioner raised a valid issue. I did live in the premises. I have an electric bill. And again, that's just a hypothetical, and I'm going off Commissioner Giacofoni's hypothetical. But if you have information for us that we can consider and use as part of this hearing, we'd be glad to listen to it. But to just keep reiterating the procedural issues that you have is not going to be sufficient, at least in my mind.
So then one argument I can make is that, well, first of all, I'd like to have this introduced into evidence, can we?
And what is on that is circumstantial to what we're asking you?
That's a recording of your conversation with Mr. Nunez?
And the day following Johanna. So
The
that's
phone
procedural.
conversations?
With
And
our
then-
director?
Yes.
Okay, and what else do you have?
And there's also the deputy director following the hearing, where they told me, that's it, I can't do other things. But then, argument, the election administrator testified, one of you guys asked, did he present any evidence of residency? And he said no.
Okay.
And I had provided him, this rent receipt. I have a few copies.
And those are on your behalf. I'll take them. We're going to swear you in to introduce those, or you don't want those introduced? How am I going to get those introduced? Are you saying that those are your rent receipts?
I'm arguing that there is communication made to the election administrator where that was introduced at that time.
You're saying that was part of the lower record?
Yes, and when it came before the board and the respondent responded and was asked on direct, did he provide any evidence of residing there? He said no, and that wasn't true. And that's argument.
I'll mark that for the record. I would like to know for the board that, again, we're talking about evidence that was not and could not be introduced at the time. It sounds like that actually was introduced, but I'll mark it. Is it all one exhibit?
It's all the same. I just made copies. You can just take one if you like. Oh, if you want to share with the board at their discussion. One of you take it.
We'll mark that as exhibit, we'll mark that as exhibit A,
Well, I think you
and
already
we'll
had an
mark
exhibit,
the recording as exhibit B.
and
go
you had
ahead.
another, I believe you already answered.
The only other thing that we introduced was exhibit 1,
Oh, okay.
which was the email from Mr. Nunez. And so we'll use letters for you, and for the boards, we'll use numbers. Okay. I do not have before me all of the information that was provided. I do remember that the administrator sent out a letter to an address in Ward 3 that was returned, in which the landlord said you do not reside at that address.
There's a copy of that in your packet. Yes, of those letters.
Is that the same address that we have here, or is that a different address? This is the address of 14 Old Fort Road.
Just to be clear on the declaration of candidacy, this is 320 Dame Street. And this is a receipt for 14 Old Fort Road.
This
I
was-
don't know the wards in Newport, so I don't know which is in.
I don't either, but
Ward
this was,
3.
this was an attempt to show that you were in Ward 3 as opposed to Ward 2, right?
The declaration of candidacy asks for a street address, not a residence address. Board member.
Okay,
This is the.
Just to be clear, he put a P.O. box on his declaration of candidacy.
I put the street address of my PO box, that's correct. But it asked for street address, it did not ask for residence address.
Can we just go back to what the chair asked you? Do you want to be sworn here today to provide us
No,
with? testimony?
I'm not making an argument, I intend to make an argument.
But now you're
So you
introducing
don't intend to-
exhibits,
Oh,
and you're
sorry,
saying
Rick.
that they're exhibits that were part of a residency, so that is testimony. You can't have it both ways,
Right.
so
I-
that's
I-
entirely up to
Again,
you.
I'm here for a motion to reconsider. I
Okay.
agree with that on procedural mistakes and surprise that occurred. I requested that we go into executive session to discuss all of these matters in full. That was denied.
Well, what's the
and we're
basis
not
for the
here to have
exec?
the hearing
What's the
today
basis for the executive session? Why do you need it in executive session? Why can't you tell us in the public?
Because I'm not here to have a hearing today on the hearing itself. We're only here on the motion to reconsider, to open this back up. And it's not on the schedule today. It's not before the board.
If we went into
The fact
executive,
that I even introduced anything now is beyond what is before the board today. The motion to reconsider is on.
Okay.
At your insistence, Vice Chairman, I have given you,
Okay.
given you a
So-
little bit.
So have
But
you
I
made,
have
have
more.
you completed your argument on the motion?
and while you look, Commissioner Connor, sorry, you had your,
I actually agree with his last statement. The only thing that the board is considering today is the motion to reconsider. So the fact that we're looking at
Yeah.
receipts and everything like
Yeah.
that, that's almost like we're having another hearing.
agreed.
So we need to ask ourselves, are we going to reconsider the appeal? The fact that we had a meeting on the 15th and Mr. Sivko was notified of that meeting means that we held an abbreviated schedule. We had a hearing. We decided the hearing. That matter is over. Are we going to reconsider the
Yeah.
appeal? That's the only question, as far as I'm concerned. So. I agree. I'm not comfortable looking at
Agreed.
things that should have been entered during the actual hearing.
Agreed.
I agree that that there is, the abbreviated schedule was entered. I just, abbreviated schedule took place. I just disagree that it was entered by the board itself, if the board had not met.
Because we
This is
don't,
the board.
that's not
It's not
procedure. We don't, right? Ray, am I misspeaking?
The board staff set the schedule for this case, given the imminency of the election that was taking place in 2024.
Right, because of the primary coming up, but in this particular case, there was no reason to have an amended schedule, so we had everything in time for the primary, because even if I win my appeal and I'm put on the ballot, it's not until the general. So
But we need to print out tickets for, like, the Secretary of State needs to print ballots out.
Those have to go out
soon.
45 days before the general election to anyone overseas. So the idea that we could just sit on this until closer to November doesn't apply. The Secretary of State has its deadlines too, and we have to, which are, by the way, governed by federal law. So there's no daylight in between these deadlines. They happen in very rapid succession. And people running for office need to be aware of that, as does this board. And we all run under the same schedule set by the General Assembly, no exceptions.
I would just fall back on again that as procedure filing an appeal takes place after filing A and after the response was not entered, part B, we skip all the way to part P, public hearing. We did not go through the briefing schedule and submissions. We did not have an opportunity to enter a stay pending appeal. The record on appeal was not allowed to be produced. I didn't even get the electronic transmissions until after the hearing itself.
And,
The electronic recordings of what was on appeal. I got them after.
but again, we're here to make a decision on whether or not to reconsider. With the argument you've made thus far, I see nothing new to the argument that we didn't hear on August 15th. So again, if there is something new and now we're starting, to Commissioner Connor's point, we're starting to look at things, you got to be sworn in. We're trying, like, sir, I am trying to help you. I have a great respect for any citizen that wants to run for elected office and, be a public servant. I truly do, but we can't supersede what is need for you to be sworn in if you're going to provide testimony to present something that we don't have knowledge of.
Like,
Current date.
like I
current
said, I'm not
time.
trying to introduce this as evidence. The vice chairman asked me if I had anything. I do have things.
Okay.
Again, it's not what we're here for today. It's the hearing on the reconsideration. The reconsideration as introduced and set out by your legal counsel at the beginning was unless there's a mistake or surprise. And I would just say that mistake is I did not have the opportunity to file my full 10 days to file my brief. And that the surprise is given a 48 hours notice that it'll be taking place at 4 p.m. The change of time. So, I mean, that's it.
You want to move it? You want me to?
Yeah,
move it?
I was gonna make a motion to reject the reconsideration.
I'll second it, and I'll second it based upon the fact that if we review the rules of civil procedure as presented by counsel, the factors of mistake, inadvertent, surprise, excusable neglect, newly discovered evidence, fraud, the fact of the judgment being void, the judgment being satisfied, or any other reason justifying relief have not been presented here as part of the motion, and I would second that. Commissioner's motion to reject.
Okay, we have a motion and a second. Any further discussion on behalf of the board? Hearing none. All in favor signify by saying aye. Aye. Any opposed? Any abstentions? The ayes have it. Thank you.
Thank you for your time.
Motion to adjourn?
Oh, why am I just sitting?
I wasn't sure what was happening.
Aye.
I'll second that motion.
We have a motion to adjourn. Moved and seconded. All in favor signify by saying aye.
Aye.
Any opposed? The ayes have it. We are adjourned at 3:21. Sorry.
I don't know how you could have helped him any more than saying, like, let him testify.